So let's start. Thanks a lot, Anne. I think we can start now.
Yes.
Yeah. Good afternoon, ladies and gentlemen. Good afternoon, everyone. I think we have a good number in the room. Good afternoon. So very briefly, I'll introduce myself. My name is Ungo Martin Zokoma. I'm a partner in the law firm of Aluko and Uyebodi, where I work in the dispute resolution practice of the firm. I also lead the construction practice of the firm. In addition, I'm the chair and founder of Africa Construction Law. African Construction Law is a Pan-African organization established by construction law practitioners from across Africa and the diaspora. It serves as a platform for the comprehensive exploration and advancement in the field of construction law, encompassing both front-end development, project financing, and dispute resolution throughout the continent. I'm absolutely delighted to welcome you all today to this webinar, which is focused on dispute avoidance and adjudication board in construction projects. The webinar is jointly organized by the Africa Construction Law and the Construction Law Institute. The Construction Law Institute is a professional think tank fostering collaboration, knowledge sharing, and development of best practice in construction law. We thank the ACL and the CLI for this very important collaboration. Diving straight into the business of today, Dispute Avoidance and Adjudication Board, which is otherwise known as DABs, have become increasingly significant in modern construction and infrastructure projects, particularly in managing risk, promoting early resolution, and ensuring project continuity. As construction and infrastructure projects grow in complexity and value, effective dispute management mechanisms are no longer optional, but have become absolutely critical in today's age. Joining me in dissecting this topic are three eminent and very experienced professionals in the use of DABs. And I will very briefly introduce them for your information. We have Engineer Boala Lombwe as one of our speakers today. He holds an MSc in construction, an LLM in construction law. He's an arbitrator with over 43 years experience covering building, civil, and mechanical construction in Zambia, Tanzania, Mozambique, and Congo. He's a chartered arbitrator, a fellow of the Chartered Institute of Arbitrators UK, a FIDIC certified adjudicator, and a FIDIC certified trainer. He's also a registered engineer, a fellow of the Engineering Institution of Zambia, and the Chartered Institute of Building UK, as well as being a chartered construction manager, a member of the American Society of Civil Engineers, and the Association of Consulting Engineers Zambia. Engineer Boala is obviously very experienced, and we are very, very privileged and happy to have him as part of the panelists today. Next on our list of speakers is Thierry Lyons. He's a senior managing director in the construction practice of FTI Consulting, heading the Paris team. He joined FTI Consulting in 2016, having spent most of his professional career on major oil and gas and infrastructure projects. Thierry has over 20 years of experience managing the various components of project controls, both on contractor and client side, and has been extensively involved in the setup, management, and development of activities of project control, budget, cost control planning, contract, subcontract administration, risk management, analysis of key performance indicator. As such, Thierry has developed a comprehensive knowledge of issues relating to cost scheduling, procurement risk, and contract management within the construction project industry. Thierry has over 36 testifying experience in ICC arbitration, both as delay and quantum expert, and has been selected by the Who is Who Legal as being amongst the world's leading consulting experts regularly since 2018. Thierry, thank you very much for being with us today. And then we have David Kagwa. David Kagwa is an international arbitrator and construction lawyer with over 18 years experience in representing clients in resolving complex disputes involving major infrastructure and construction projects. He is the chairman of the Chartered Institute of Arbitrators, Uganda, a senior partner at Kagwa and Kagwa Advocates. David has acted as counsel and arbitrator in several construction-related arbitral disputes, both under major arbitral rules, including the UNCITRAL rules, the ICC, the LCIA, and the rules of the Chartered Institute of Arbitrators. David has delivered an arbitral award, which has all been enforced by the courts. He's a fellow of the Chartered Institute of Arbitrators, a fellow of the Institute of Construction Claims Practitioner, a member of the London Court of International Arbitration, and many other organizations, too numerous to mention. David, thank you so much for being with us today. Thank you. So diving straight into the subject matter of today's conversation. David, could you just please briefly tell us what are DABs and how is it meant to work in practice? Could you give us a very quick overview of what DABs is all about?
Well, thank you, Martins, and thank you, my fellow panelists. And thank you, participants, for joining this very important webinar. I've prepared just a few slides that will enable us to memorize this aspect of DABs. And I'll go straight into it. So DAB is a short form to mean Dispute Avoidance and Adjudication Board. It was introduced under the FIDIC 2017 suite. It's a successor to the FIDIC 1999 suite, where it was referred to as a DAB, Dispute Adjudication Board. Dispute boards are panels of experts or a single member that avoid or resolve disputes on construction projects. Dispute boards are effective tools for dispute avoidance and resolution in construction projects, evolving from non-binding recommendations to binding decisions. So how do the DABs work? They work in the following ways. They're comprised of experienced construction professionals who ought to be impartial. They may be engineers, architects, surveyors, or construction lawyers. Of late, clients prefer a mixture of professionals to ensure that there is a one-stop shop for expertise. So it's common to find DABs with an engineer, an architect, and of course a construction lawyer. So the FIDIC 2017 subclause 21.1 requires that the parties jointly appoint the members of the DAB within the period stated in the contract data after the contractor receives the letter of acceptance. The DAB comprises 3 members. Each party may select 1 member for the other party's agreement. And once the 2 nominated members have been agreed, the parties will seek the assistance of the 2 members to appoint the chairperson. If no period is stated in the contract data, then the appointment must be the appointment must be made within 28 days.
I'm saying the numbers of people in 10 minutes.
And please, could you mute your mic, please, Anne? Please, David, go on.
Now, DAB is appointed at the commencement of the project and stays in force during the entire construction period, emphasizing avoiding disputes or resolving them when they occur. So parties are obliged to provide the DAB with key documents. These include the contract, progress reports, baseline program, the impacted program, meeting minutes, and other documents. There is a DAB where I sit where a platform has been set called AirSite, where all these documents are uploaded in real time, so the parties and the DAB members can access them wherever they are. So the DABs hold periodic joint meetings with the employer, contractor, and engineer, and give advisory, non-binding opinions on potential issues. DABs encourage the parties to discuss and negotiate key issues that affect the time for completion, financial claims, and quality of works. The DABs also encourage the resolution of issues and claims at job site level before they escalate into fully blown disputes. DABs make formal binding decisions that must be complied with unless reversed through arbitration or litigation. So over to you, Ngo Martins, to take over the conversation.
Yeah, thank you, David. That's a very very quick overview, and thanks for the enlightenment. Engineer Bala, my next question is to you. Apparently, you know that one of the justification for DAB is the fact that it allows for, it allows for real-time resolution of disputes, rather than allows situations where claims are piled up and then it becomes a complication during the life of the project. Obviously, it serves a critical it has the critical purpose of dispute avoidance, and where those claims arise, you have real-time resolution of the dispute as the project keeps running. Now, what are the challenges of getting a DAB constituted? David has sort of given us how the appointment works and how how the mechanism is meant to actually work and operate. From practical experience, having been on many live projects where where the contract provides for DAB, and you have a situation where it's meant to be constituted, what are sort of challenges you've seen in practice? Engineer, you might have to unmute, please, so that we can hear you clearly. Thank you.
So sorry, I keep forgetting that. Thanks, Ngo, and thanks everybody. There's quite a number of challenges in constitution of dispute boards. One of the issues that often arises is that you find that the DAB fees and costs are often not included in the contract. That in itself delays the actual constitution till the parties find a way of going around that particular problem. That is number one. Number two, parties quite often believe that the DAB is a cost, right? And has no benefits. And I think we've seen quite a number of reports and of late that the benefits of DABs, having a DAB on site, far outweigh the costs that parties worry about. Right? Number three, parties also believe sometimes that they'll be able to resolve their issues without any reference to the DAB. Right? And number four, this is one I've read about 2 times. Parties actually believe that the DAB is an auditor and will be reporting issues of failures and issues of shoddy deals. Right? I've read this a number of times, and parties are afraid to set up the DAB because of that. The last one, that often parties are not aware of the functions, success levels, and the dispute preventative. And this is dispute prevention role played by the DAB. Mm-hmm. So I think as we proceed, we need to educate the employer and the contractors. And I don't know how many contractors and the employers are on this website, on this webinar. Usually they are very few when it comes to these things. There's a number of challenges as well, Ngo. Right? Once the DAB is constituted, the parties quite often fail to cooperate in agreeing to site visits. So they are maybe been forced to do a DAB, but then when it actually starts off, they start proscribing. Right? Number two, parties fail to keep the DAB updated with information such as critical correspondence, variations, instructions, etc. As you mentioned, we are supposed to do these things in real time. And if the DAB does not get that information when it's not actually visiting the site, right, then the purpose of a DAB begins to fail, right? Another one is parties fail to employ the dispute avoidance mechanism, which I think the 2 of you have already mentioned. They are for some reason afraid to come to get informal assistance or discuss their issues with the DAB. Another one is simply failure to pay the fees of the DAB. This happens quite often. Best practice, Ngo. As we said, the last, I don't know how many people have seen the King's College study on disputes, right? A large proportion of disputes never actually go to arbitration because, as we know, DAB is a first step, part of a step to end up in arbitration or litigation. In under FIDIC, for example, it is the engineer's determination, the DAB referral, and eventually arbitration, right? Those reports show that a large percentage of disputes never actually go to arbitration because they're accepted by the parties. The vast majority of the small number that go to arbitration are upheld. Informal advice is quite often accepted by the parties, and there are no further reference to the dispute board. So you can clearly see the advantages of a dispute board. So what is the best practice? Employers ought to ensure that an estimate of the DAB and fees costs are included in the tender documents. Funders, African Development Bank, for example, can include a mechanism of contract not to proceed, right? This is something that has been talked about by these funding agencies, that they will do that the project should not proceed post letter of acceptance unless or till a DAB is in place. This is a big failure in a number of projects where the funding agent has got no mechanism, particularly if the two parties, right, really don't want to set up a DAB. There is really no mechanism under the contract that you can resolve to push. If one party is proscrinating, there is a mechanism for that. You can go to an appointing authority, right? Even that sometimes is a problem, because what usually happens is that, particularly if a contractor wants to go to an appointing authority, the other party sees that as a start of a fight. Now, the contract allows you for that, and you find that contractors are usually keeping away from that until the parties, I think. I've been contacted for the last 2 years on a project somewhere in Tanzania, and this is a problem. I keep being told that the parties haven't made to decide. Right? It's 2 years down the line. It was a 3-year project. I don't know exactly what the details are now. Okay, thank you very much.
Thank you so much, engineer, for that enlightening expose on this. I mean, you talked about the various challenges, which is quite packed. I'm hoping that you'll be able to unpack them as we go on during the course of the conversation today. Thierry, just again around these challenges, let's talk about the subject of trust, because I mean, without trust, we can't, I suspect the entire mechanism is built on trust. Arbitration is built on trust. And so it's also very important that the parties are able to trust the process with respect to DABs as well. So, I mean, from your experience, the project stakeholders generally trust the DAB members will act impartially. Do you encounter concerns about this bias? What has been your experience in building trust in dispute boards and issues around neutrality? And how do you address this perception? I mean, Thierry, I had a situation where, an experience where, because of the lack of trust, we couldn't just proceed that was a dispute adjudication board. We couldn't proceed with that process. So I think this is a very important question. Thanks.
It is. It is an important question. Thank you for having me. Well, you said it. The whole process revolves around trust. So I think trust would come out of the first encounter. As Engineer Bwalia said, there's a first step where nobody has met, but you're making an appointment. Somehow, parties decide to appoint somebody to name that person for a very important matter, to be able to continue the project, to resolve a commercial issue, or to anticipate any issue. So, of course, trust will be very important. And for me, it is built the first time we meet personally. How do I do that? I do that very simply around a meal. It's very important, and I think it's very different from when you select an arbitrator or even a counsel, that the DAB process can start around a meal. I know I may sound weird here, but that's the thing. It's people gathering and gaining trust in each other. So the DAB, either single DAB or three-person DLB, will have to showcase that they trust in the project, trust in the parties, and trust in that relationship so that the parties can give back that trust. Now, I've been involved in quite a few DBs as a member myself, either single board member or a three-person member. Let me give you an example from just yesterday when I was asked to sit on a new board, and it was the employer calling me and saying, well, we don't know you. How can we trust you? And I just answered, you can't. You can check that I'm on the FIDIC president list. You can check that I have a long CV. You can see me smile speaking to you. You can appreciate that I didn't give an extraordinary price, but a very nice one for you guys. But the trust will come into the fact that I trust your project. How do I establish that in practical terms? Is the first meeting or the first few meetings, in particular if it's at site, is to recall all parties of the objectives of the project, not the objective of the employer who wants the project, not the objective of the contractor who wants to make money of the project, but the objective of the project. What is it? Is it an infrastructure to serve the people? Is it a water treatment or a power plant that will produce something useful to the people? And that's by going back to that objective that I'm trying to establish the trust. So to build that and to get that perception, I'm not working for the contractor. I'm not working for the employer. I'm not working against them either. I'm working so that the project objectives will be met. And doing that, trusting in that, ensuring that this is the line of thought of everybody and not only their own interests, will be the way we go forward together. I mean, looks like I'm giving you a solution, but it's not a solution. It's just a first step into that relationship. Thank you, Ngo.
Thanks, Thierry. Thank you so much. Staying with you further, I mean, closely related to trust is also questions around, diversity and the makeup of the DAB panel. So from your experience, does the makeup of the board, for example, mixing legal and technical experts, gender issues or regional diversity, does it influence the DAB's success? Are we seeing enough diversity in the DAB appointments? And do you think institutions should be doing more to broaden the pool?
Yeah, well, this is a good follow-up, in fact, because as I said, there's objectives of the project and not of the stakeholders or the parties. And there is this interpersonal relationship which is guiding the process. We have a problem of diversity. We do have. Proof is that, well, two examples. Once I was contacted for a North African project, very small infrastructure, a road, and they said, we want you as a single board member. I say, okay, but I don't know you. I don't know the employer. How did you come to choose me? Well, we went to the FIDIC website. We sorted out the people who know our industry, who can speak the language because it was in France. So they used filters. And the guy told me, you were one of the only three names remaining after the filters. And I found that, I mean, I was very happy to be chosen, but I find that appalling because we need more people, men, women, people in Africa, people in Europe, people wherever they are, in languages, in French, in English, in Portuguese, in Swahili, I don't know, to be able to answer to the specifics of each project. You want a dispute board member who will have an understanding of your project, who will have a good comprehension of what you're doing, what is your cultural background, what is the legal background, is the country you're working in a common law country, a civil law country, something exotic. And one of the answers to do that is to have more adjudicators or board members on the market. The second answer, of course, if the project is big enough, is to constitute a 3-person tribunal, which will allow to have, for example, somebody who has a good engineering background, somebody who has a good legal background, and somebody a good commercial background. And although they each will have many skills, their core skills, will complement each other. So for me, the makeup of the board with a mix is an absolute. When you have 3 people, you need to have a mix. It's exemplary, but it's also mandatory. And I have even seen some organizations who are very used in the use of dispute board, like, for example, the World Bank or the MCC, who are pushing for boards who establish guidelines saying, look, the parties need, of course, to name one each, but for the third one, the president, well, we would want to ensure that he has a background that complements the other. It happened with me in France here for the work around Paris, very big works in billions of dollars, where I was appointed, another guy more technical was appointed, and we were told, you can choose your president. You have all the liberty to choose him as long as he is a legal guy, because you both don't have a legal background. And that is very true from the employer and contractor. That means they have the interests of having a functioning board at heart. And this is very important. Now, the parties, the association, be it the Chartered Institute of Arbitrators, the Dispute Board Foundation, etc., the FIDIC even, also have a role to play in promoting training, allowing to have a larger pool of people who can take part in a DB, as well as ensuring this pool is not reduced for, I'm sorry to say that, Go Martins, but to lawyers, as it has been for many years. It was more of a law profession. Now opening to a lot more people, different backgrounds, who will bring a different view and a different added value in the project is key. So some associations, some banks even, organize training, encourage people to go and get certified by FIDIC, for example, so that the pool is larger. It doesn't mean that by being in the pool, you will get hundreds of appointments, but it means you're here to broaden the skills. And someday, when somebody looks for an adjudicator who speaks both Indian and French and know the water treatment industry, well, it can be found that we have that capacity somewhere. And that is very important for the associations and institutions to support that effort, and even, if they can, to fund that effort. Very often, and we will do that in Nairobi in a few weeks, there are conferences which are very nice. But around the conferences, the day before, the day after, there's a training organized. And it means that for a very low amount of money, people can get trained also. And that's very commendable from the associations to organize this in addition to the conferences, to promote the system and to promote the people who want to be part of this dispute prevention system. Over to you.
Thanks a lot, Thierry. And yes, the Africa Construction Law Conference is coming up in Nairobi in May, and we'll be doing, dispute board is also a very key subject that we'll be discussing during the conference. Thanks. Engineer Boala, my question is to you right now. Thierry has mentioned how critical, diversity is to the outcomes of DABs. You mentioned a few minutes ago, you referred to the King's College survey that has talked about the growing importance of DABs in today's world with the adoption of DABs for many projects, even by, projects being financed by many multilateral development banks on the African continent. So the question is, what can be done to ensure increased African participation in this very critical and significant, space? How do we have a lot more, Africa participation in the DABs?
Thank you, Ngo. Perhaps let me start with Thierry mentioned the FIDIC President's List of Dispute Approved Adjudicators, right? This consists of members who are listed, who are suitably qualified, been assessed, and hold the FIDIC Certified Adjudicator Certificate. And that's a good starting point if you're looking for an adjudicator. Now, in as far as Africa is concerned, and I'm talking about Africans, not those dispute people who appear on the dispute on the president's list who stay in Africa, right? I'm talking about people who are actually Africans. Out of 120, I think it's about 120 of 2 days ago, right? Zambia has 3, 2 men and 1 lady, diversity again. All of us are engineers, right? Uganda has 1, Kenya has 1, Nigeria has 1, surprisingly. I didn't know that until I rechecked the list yesterday. RSA has 3, right? There's more actually in RSA, but they're not registered as Africans. They are British or some other nationality, right? So if diversity is going to occur, we need to get more Africans trained, more Africans certified. And that has proved to be a problem, I think. For example, were in Kenya with David, I think more than a month ago, and I invited people who want to contact me, and I will become the mentor. I haven't had one, right? Absolutely so. It's proving to be very difficult to get Africans sort of interested to train as adjudicators. Right. Now, if you look at that list, it is dominated by Europeans, mainly the UK guys. Believe it or not, the highest number is the UK. Right? Now, what can we do? I have 2 mentees at the moment, and I'm still looking for more. So those of you in the group that are interested in becoming mentees, please contact me. Right? I've had 1 mentee, I think he sat the exam, I think 2 weeks ago, there was an exam, and I believe he passed, or he told me I'd passed. So there we are. And we need to be doing this. Those of us who can afford that, who can have the time, we need to do that. Let's get mentees, African mentees, so that we can increase the pool of Africans. As Thierry and David mentioned, it doesn't have to be engineers, but we need a lot more engineers. There's a lot more lawyers, right, on that list than engineers or other professions, quantity surveyors, commercial guys, that sort of thing. So we need to do that. Now, there was also a study that I think it was done by Dispute Resolution Board Foundation, Smith and Reuters, 2018. When they did out of, I think, 231 dispute boards, they found that 99% were in Africa. So the vast majority at that particular time of dispute boards were in Africa. And yet we do not have Africans to sit on those boards at all. It is, for me, it is very sad. And as I said, I am always willing to mentor people so that, look, the Africans that are there, right? Most of us are this age, and I'm not going to tell you what the age is, but will not be there for long. So we need the young guys, to take up the mantle sooner or later. Thanks, Ngo.
Thank you. Thanks so much, engineer. Thank you very much. Very interesting statistics, very interesting, statistics you provided. Thanks. David, my next question is to you. We've talked about, what DABs are about, how you go about constituting it, composition, issues around, who diversity questions and the personnel involved in the system. Let's talk about compliance a little. I mean, from your experience, do parties tend to accept and implement a DAB finding in good faith? Do you often see DAB decisions being ignored or challenged? So what has your experience been? David, you're on mute, please. If you could unmute yourself. So that
yes, my experience has been that there's been little compliance with enforcement, but for the benefit of our participants, I'll just give a little background about enforcement as provided for in the FIDIC contract, so that we have context about what we're talking about. So the context on enforcement, FIDIC provides that if a party fails to comply with the decision of the DAB, whether binding or final and binding, then the other party may refer the failure itself to arbitration since it amounts to a breach of contract. That is clause 21.6. In essence, DABs have two roles: the advisory role that helps to avoid disputes and the decision-making role where they sit as adjudicators. So if they have made a decision that an employer should pay $1 million to the contractor and the employer refuses, then the contractor cannot just straight away enforce it the way an arbitral award is enforced, but they must refer the refusal to pay to arbitration since it amounts to breach of contract. So that is one method in which a DAB decision is enforced. And during those proceedings, the arbitral tribunal shall have the power to enforce the DAB decision by way of a summary or expedited procedure through an interim award. Put differently, if you go before an arbitrator and there is X amount of money which is due and payable, instead of going through the long haul of pleading, upon commencement, the arbitrator can render an interim award in respect of that amount of money which the DAB had decided. Now, in Africa, there's been a decision in Botswana where the High Court enforced a DAB decision. Now, where you see DAB without two A's, it means that's FIDIC 1999. And where you see two A's, that's FIDIC 2017. So the High Court there enforced a DAB decision as a liquidated demand in the case of Liftoff Investments versus Botswana Diamond Company Limited. In essence, there was a DAB decision, and the contract provided that the arbitrator will be appointed from South Africa. So a notice of dissatisfaction was issued by Botswana, but for over 1 year, they did nothing to have the arbitral tribunal constituted. So the DAB decision was enforced by the High Court as a liquidated demand. So the matter did not stop there. Botswana appealed to the Court of Appeal. In Botswana, the Court of Appeal is their apex court. It is similar to our Supreme Court. And this is what the court said. It said that the DAB awards may be referred to the High Court for enforcement. Courts should, as a general rule, be slow to enforce such awards, and that judicial interference should be resorted to in exceptional circumstances, such as where the contractual imperatives relating to the resolution of disputes are found wanting. This is my emphasis, and I'll explain. To ensure uniformity in enforcement of DAB decisions, the world needs a convention similar to the Singapore Convention on Mediation, which provides a uniform framework for the recognition and enforcement of mediated settlement agreements. So to put differently this, the court said that because it was difficult to have the arbitrator put in place due to the sloppiness of Botswana, the court relied on that as an exceptional circumstance that made the contractual enforcement difficult and enforced the award. So it's not easy to enforce in Go Martins, but that's where we are right now. Martin.
Thank you very much, David. Just before we go on, I would like to say that we have roughly about between 225 to 30 people that are currently in attendance, which is quite very good. I know you probably would have questions for our panelists. If you could begin to, share your question on the chat box. So there's a chat box somewhere. I think there are opportunities for you to be able to type your question and, share them on the chat box. We wouldn't be able to take all the questions due to time constraint, but as much as possible, we'll try and entertain those questions. Thanks, David. I mean, I think you've highlighted one of the critical challenges of DABs essentially on the African continent, because we do not have the statutory adjudicatory system in place. In I don't think any African country has actually enacted such statutory framework. So we still have this contractual process for enforcement of adjudication decision, DAB decisions, and all whatnot. And this might be very challenging especially when it has to do with cross-border disputes. Thierry, I would invite comments from you at this point. What's your thoughts with respect to enforcement? What's your thoughts? Do you think, David had talked about a process similar or likened to the Singapore Convention. Some people have talked about, so what's your thoughts about, enforcement basically?
Yeah. Well, I have to say, I never had to think about enforcement because I was always brought into DABs where the issuance of advice, the issuance of informal opinions was sufficient to avoid disputes, so that the dispute avoidance mechanism worked. And when disputes were actually referred to me, and I was asked to make a decision, then the parties submitted to the decision willfully, so that there was no need to look and speak into enforcement. That's my experience, let's say, about enforcement. But my point here, and I wanted to join Engineer Bwalia here, what he said in the beginning is linked with the costs, if I may. The costs of the DAB, which are often seen as a repellent, well, this is exactly the contrary. If you go into a project and everything works well, everybody is happy. If it doesn't work well, you end up in litigation or arbitration. You will spend a lot of money to settle a dispute, and that money is a cost to everybody. I'm sorry to say that, but even if the dispute is resolved commercially, then the cost of the project will be lost. Now, the dispute board stands in the middle. There are costs in having the adjudicator, the dispute board member, coming to site, having meetings, but there is a direct added value that can be measured, is that the project is much less prone to standby, to suspension, to resiliation, or to going to those expensive dispute resolution steps, so that the DAB, in providing advice and informal opinion and being with the parties to remind them of their objective and not the objective of the project and not the stakeholders' interests themselves, to remind them of that, then there is an added value. There is a direct added value, and this is why also we very often say that a DAB is not a cost, but it's like an insurance policy. You're paying so as to avoid dispute happening, okay? And so that's how it is justified also as an expense for the World Bank, for the Asian Development Bank, African Development Bank. Those institutions see the cost of a dispute board not as something wasted, but an insurance, a security policy, so that the money which is invested in the project is rightly invested and is not lost on disputes, if you see my point. Now, this is very important because it allows not to discuss enforcement at all.
Yes.
Sorry, I was seeing, Go Martins, you have a lot of questions already in the chat.
Yes, indeed. Yes, indeed. There are lots of questions. And thanks for discussing the issues about cost, because it's absolutely very critical. And like you said, it's an insurance policy. So perhaps parties need to think about it from that perspective, essentially. There's a question on chat box. I will just read it out. In respect of enforcement of DAB, the funding agency and or the employer, as the case might be, is usually the one who laid down the terms, and the contractor have small room to negotiate. What approach was taken or should be taken to convince the funding agency or the employer of the importance of DAB?
Well, maybe David wants to take that up, because last time we discussed potential mechanisms for enforceability, unlike the New York Convention when we were between ourselves. David, you want to pitch in on that?
David,
Yes, I will.
Okay.
Yes, I will. So it's the question from Mohammed. In respect of enforcement of DAB, the funding agency and or the employer, as the case may be, usually the one who laid down the terms of the contract. What approach was taken or should be taken to convince the funding agency and the employer of the DAB? Okay, so it looks like the question is about difficulties in enforcement. There are various ways. One of the ways is stated in the contract, and I have stated in my previous slides that once you have a DAB decision, you can make a demand. If it's a payment of money, you make a demand to the employer to effect that payment within a certain period of time. If that payment is not effected, then that amounts to breach of contract. So you take that aspect of breach before an arbitrator to have it enforced through an arbitral award, because it is only an arbitral award that you can take to court to be enforced as a decree, but not a DAB decision. So unfortunately, you have to go through the arbitration process. However, we are having discussions of how do we make DAB decisions more effective and more enforceable. And that is the conversation we're having. Can we have a convention similar to the Singapore Convention on Mediation, where DAB decisions are enforceable across the countries that are signatory to that convention? That way, they'll be enforced just like mediation settlement agreements are enforced throughout the world. So it's a conversation we're having. You may need to join us in Nairobi for the conference to have this conversation, because it takes with the practitioners to raise these issues such that these conventions come into force. Over to you, Robert.
Thank you very much, David. Engineer, how do you envision the next evolution of dispute boards in the coming years, and what advice would you give to projects considering a DAB to ensure if truly it delivers on its promise of dispute avoidance? In other words, what do you see is coming next? How do you envision the future of DABs, essentially?
Yeah, I think the future is good, and I think it will grow as long as people understand the benefits of DABs. The King's College is a very good standing point. If people can read and understand how DABs work and what they contribute, I think a lot more people will start to use DABs. Now, the future, the next generation. Construction is technologically behind in terms of technology, that sort of thing. As construction catches up in terms of technology, in terms of the use of building information management systems, AI, drones, that sort of thing, we will need DAB members who are technologically savvy. Dinosaurs like mine will probably never see the day of light if these things change. And I think that is important, because construction now is taking the road. They are trying as much as possible to increase the technology used. It is still a very manual process compared to other fields. So AI, BIM, those things will increase. So the DABs of the future will have to be savvy and understand all these other processes, right? Secondly, and I've referred to this already, I see more and more standing boards being adopted by other major standard forms of contract. JCT, which is a joint contract tribunal, I think it's a UK one, NEC, new engineering contract. They have DABs now. They never used to. But that is a choice, right? Unlike DABs in TDIC, which is mandatory, you have to, it's in the part of the contract. You have to choose that option. I see in the future that they will eventually move to DABs. But to achieve that, like I said, we need to have contractors, employers, and funding agents to understand. 2 years ago, Thierry, I don't know if you were in London at the FIDIC International Contract Users Conference, where JICA, who have a manual on dispute boards, were simply saying, we don't care. It's in the contract. As long as for us the contract starts, it doesn't matter whether there's a DAB or not. The World Bank and African Development Bank have for years been promising that they will do something to ensure that before money exchanges lands, there's a DAB in place. That hasn't happened up to now. I think for now, that's all I have to contribute.
Thank you, Engineer Boala. We have another question here, and I'm not sure, probably Thierry, you might want to take this. How independent are DAB members since they are appointed and paid by the parties?
Well, the DAB member, it's easy. I act as an expert as well. The question is harder for an expert. For a DAB member, as well as the arbitrator, you're entirely unbiased and independent because you are paid 50-50 by each party. What does that mean? Well, very easy. Each party pays for half of your time, meaning you don't have any interest into giving favors to one or the other. You have all the interest in the world as a dispute board member to be very fair and independent so that this is known. And the next time people choose you again. It's very, very easy. Now, the way to ensure this or to ensure there is no doubt is very often to choose somebody who is not into your own network. For example, I work as a DAB between a bank and a contractor who is Egyptian. I've never worked for one, for the other, never known them. Perfect. Maybe Engineer Boala would be appointed in a country that is not his, nor the one of the employer or the contractor. That avoids any type of bias or problems with independence altogether. I talk about the geographical area and the nationality because usually it's where you see whether you have links with one another. But simply said, the payment process, the fact that you are paid by both parties makes it very simple.
Thanks a lot, Thierry. There's another question from Prudence, which is quite interesting. It says the adjudication board needs to state, or does the adjudication board need to state the magnitude, nature, and complexity of disputes whose adjudication resolution should be considered as final and can only be contested, stroke appealed on similar grounds provided for arbitration appeal?
Well, that is.
I'm not sure if this question is trying to say whether there should be categories in terms of the kind of decisions by DABs that should be appealable and those types that should be considered as final.
Yeah, I would think people, some people would need to join us in Nairobi to explore that further because it would be a long conversation, but it depends on the jurisdiction as well. Each country has different laws and different acceptance of the adjudication process. For example, in France, in public contract, no decision is binding and final if it's public money. So there is also a different way the dispute boards and a limit to the powers and to the to the extent of the dispute board decision. So you would need to review that depending on the jurisdiction, of course.
Yeah, thank you so much, Thierry. Thank you. I mean, our panelists today have been fantastic. I think we're gradually coming to a close, but just before we wrap up, I would just want to, you know, have your take, 1 minute take on, you know, what you think before we close. And I'll start with you, Engineer Boala. So if in 1 minute you can just, I mean, let us know, you know, what do you think about DABS and its future? I know you've said that, you know, previously, but any closing remark essentially?
Well, I think for me, I think I've said that these are successful, DABs are quite successful. And for me, the most important thing is to get more Africans onto DABs. I've already seen that there's a number of people interested, and I've asked the secretariat to share my email. So
Excellent. Excellent.
let's hope it'll work. Thank you.
Thanks, Engineer. David, any your closing remarks in 1 minute, please.
Okay, thank you, Ngo Martins. My closing remarks is that DABs work. They work. There is statistics to actually show that most of the FIDIC DABs that are constituted under FIDIC, 80% of their decisions actually are enforced. It's only 20% that goes to arbitration. So maybe that's one of the reasons why for a long time engineers used to do adjudication and we lawyers used to wait for arbitration. But when we read the statistics, that is only 20% that comes to arbitration. We've now gone to take the cake of adjudication. So it really works. And first of all, and lastly, I need to emphasize that what we are doing, SCL and CLI, is to promote a quick resolution of construction disputes. And the quickest way we can do it is through DABs. So we're engaging in this learning, we're engaging in all this talk to see if there's a mechanism under which we can have this work. I invite you all to go to Nairobi to attend the conference. And I wish to tell you that at Construction Law Institute, we have taken it a step further. We've created an adjudication panel from which parties can appoint adjudicators. So there's, of course, the option of going to the FIDIC President's List. There is the option of going to the Ghana Institute of Professional Engineers, but we've also created a panel. The parties need to have options under which they can choose these boards. Thank you very much.
Thank you so much, David. Thierry, any last closing remarks from you? Thierry, you're on mute, just in case you can hear me.
Yes, again.
Just 1 minute.
Yes, 1 minute. In order to promote the use of dispute board, so with all stakeholders, contractors, employers, funders, as well as to have, and I agree it's needed to have local adjudicators, African or Asian, when the day you go to Asia. So you need training as well. The training can be two sides, either, and I've done quite a lot with the ICC, the CIR, some associations, some bank who allow for a big group to be trained at a low cost. So this is great. And there's also something you can get, everybody can get, is when you actually appoint an adjudicator on your project, do remember that all the project members will be in fact trained for months, if not years, by the contact with the adjudicator and the dispute board. And this is actually, I've seen that in a few companies, a great way to gain trust in the process by trying it and being part with the adjudicator into that process, trusting it, and then going further, maybe in education or becoming an adjudicator yourself.
Thank you very much, Thierry. Thank you. Again, ladies and gentlemen, if we could just give a virtual round of applause to all our speakers. I think they've been incredible. Thank you for taking our time out of your extremely busy schedule to share your insights, your experience, practical experiences on this very, complex and also very topical and important subject, especially for us on the continent of Africa. I think, Bola, you had read out the statistics, which shows that there are a lot of African projects. Many of these projects where dApps are involved are on the African continent, and there's very few African representation in this critical space. I'm very, very impressed and happy. In fact, as I speak, I think we have 255 participants, which shows how, it's a testament that this is a subject matter that is absolutely very critical, that there's quite a lot of interest. And I believe that this is only the beginning of a very, very interesting conversation. I would also like to thank all of you who have joined, not just joined, but you've stayed from the first minute up until now. Thank you very much. For those of you who took out time to share questions, to provide comments, remarks, or to even just say thank you about and express your thoughts about this session, I say thank you for the engagement, for your participation. We very much appreciate the warmth and those comments as well. Lastly, I would like to mention very importantly that in May 2022 to 2023, 2025, there is a very important conference that is being organized by the Africa Construction Law that's going to be held that it's holding in Nairobi, Kenya. It's a very important conference focused on construction law. The theme is basically about the future of construction on the African continent. We are going to be discussing a diverse range of subjects, dealing with all the critical issues you typically encounter during a project's life cycle. And one of the panel is going to be dedicated to discussing, dispute boards. It's going to be an Oxford-style debate, and some of our panelists on this webinar is going to be part of those conversations as well. So I encourage all of you to please attend. If you are not aware, please inform, get acquainted. We're going to share more information about the event on the chat box. We'll provide links to the event, as well as registration for the event. You're still able to take advantage of the early bird, which I understand closes next week. So please take advantage of the early bird. Make sure you register. It's going to be very interesting. We have a full complement of 8 panel over the course of 2 days, discussing and brainstorming very critical issues that is going to shape the future of construction law on the continent. In addition to that, there's also an annual gala dinner and an award night that's going to be holding in the evening of the 23rd. It's going to be lovely. So I encourage you to attend. Please register if you've not yet registered. And I mean, we all on the panel today, we all are looking forward to seeing you and to receiving you specifically and especially in Nairobi come the 22nd of May. The details of the panelists for this webinar is going to be, please can you also assist me in putting it on chat box for as many of you who want to reach out to engineer and any other speaker, you have a question. Obviously, it's a 1-hour session and you may have more questions. Please, you can reach out directly to them as well. Or alternatively, you can reach out to us, the CLI or the ACL, and we can definitely put you in touch with the speakers as well. So thank you very, very much. We also want to use this opportunity to thank the CLI. I think this collaboration has been fantastic and excellent. David Kagwa is the executive director of the CLI, and I would also like to invite him to give a closing remarks in his capacity as the executive director of the CLI, just before we close this webinar. David, please.
Oh, thank you very much. And fellow panelists, thank you very much for this. Where there is CLI and SCL, the best we can do is to collaborate. And this has been very good that we are collaborating to make sure that we spread the gospel of construction law in Africa and also the entire world. To the Ugandan participants, this is to confirm to you that our regulatory body, mainly the lawyers, the Law Council, granted 10 CPD points for attending the conference. please ensure that you attend the conference. And to your panelists, see you in Nairobi, and have a good evening.
Thank you.
Thank you so much. Thanks, everyone.
Yeah.
Thank you very
Thank
much.
you.
Yeah,
See you.
thanks. Bye, everyone.
Bye.